specifically impacts that might result from wave energy development. So just to get into a little more detail about what these levels were, okay, the level 1 was the highest level of protection. These were discrete resources generally. Generally, these are resources that have little or no opportunity to relocate or use other areas. So these are fixed resources. Something like a kelp bed, if that gets impacted, that kelp bed can't pick up and move somewhere else. It's fixed in place. And these were deemed to be the least compatible with development, and as a result would receive the most stringent review standards. And the components of those are rocky shores, subtidal rocky reef, kelp beds, seabird nesting colonies, pinniped haulouts, Endangered Species Act, critical habitat, and then as Andy mentioned in his earlier presentation, these core hotspots that was developed from this Mark Sand modeling exercise. And these level 1 resources covered 60% approximately of the territorial sea. The second, the intermediate levels, these were more diffuse resources, a little more spread out. And the main components of that were some foraging areas that we identified, marble meerlat and gray whale, and then these kind of what we call the broader, more diffuse hotspots for the Mark Sand analysis, about 22% of the territorial sea. And what was left over basically was the level 3. These areas still have ecological value, but they're deemed kind of less vulnerable to impacts. And these would have the least stringent review standards. Again, that least stringent is relative, it's still a pretty high bar. And these are generally resources that are more common or widespread. But also, importantly in this, I included that bullet there that says data gaps. And sometimes when you do this kind of exercise, you could accidentally, so to speak, classify an area of less importance. It could be due to a lack of data rather than a lack of resource. So we have to always remember that there could, some of this could be a result of the lack of data, and the review standards needed to be built such that that could be taken into account. That and basically what that is that you use the best available data at the time, and if that's not deemed adequate, then the developer needs to actually collect the data to to basically fill that data gap to make sure that there aren't those critical resources there. So that culminated in basically a recommendation map of the 3 levels. This map was presented to the working groups. It was presented to OPAC and the public, and it's kind of the basis for the next step in the process. Touching briefly on the fishery data, there was sort of an analogous process going on at the same time where spatial distribution of fishery importance was collected through a pretty extensive process of interviews with fishermen. It was a study that was conducted by EcoTrust and headed up by Andy Lanier and Paul Clarence were heavily involved, and others as well. This particular example is a Dungeness crab, kind of statewide importance. But these maps that were developed looked at the fisheries from a couple of different angles, and divided it by sector, divided it by port, trying to get at making sure that as many of the important areas as possible get represented. There was a subgroup or the working group that took this information and did a kind of an analogous level analysis, level 1 fishery value, level 2, level 3 fishery value. So once these pieces of information were developed, the ecological and fisheries resource information, they were brought together to start formulating where these different management areas would be located. This is kind of a simple example here with the conservation areas. First of all, looking at the level 1 natural resource information. If you overlay the fishery information, you see that starts to fill out the territorial sea further. And that information then was translated into the resource use and conservation areas. You see there's a pretty good correspondence between the area occupied by the territorial sea in the left-hand map and the right-hand map. And there does look like some missing pieces, little cookie cutter pieces of the map. And these, in fact, are just some of those other management units that are actually completely restrict ocean energy development. So those are actually kind of a more stringent area. So the designations, the spatial designations that were determined from natural resource information in combination with other information were the area designations, which were the conservation areas, management areas, and the site suitability areas. That's kind of the main kind of Appendix B map that you see in the plan. But there was also kind of a second kind of overlay layer of what we call the ISUs, the important, sensitive, and unique areas. And these were mostly kind of these discrete areas, these rock habitat areas, which include things like kelp beds and subtidal reefs and rocky intertidal areas, pit and pet haunts, and seabird nesting colonies. Those were the initial recommendations for ISUs. During pretty close to the end of the process, maybe the second to last OPAC meeting, there was concern brought up about the importance of the territorial sea areas that are adjacent to estuaries and river mouths. And OPAC took a vote and voted that those would also be included in the ISU area. So those are included as well. So this is a little bit different take on the slide Andy showed. So all this was brought together and resource protection standards formulated for these. And this kind of shows that increasing level of stringency or number of standards that have to apply as you move from the ref sites to the management sites to the RUCA sites. A little bit different take here with the ISUs and the important, sensitive, and unique areas. You see the first site there, the study areas, the standard is no significant adverse impact on ecological resources of concern. So that's, as I said earlier, a pretty high standard. As you get to the next level, you have to meet that standard, plus there's identified foraging areas that are kind of called out, and those are mapped in Appendix B of the plan. So those have to be considered. So you move to the conservation areas without ISUs, and I'll explain that in a minute. You basically have the same standard, but when you move to the resource conservation areas that have ISUs, you get to a much higher standard where it starts out with a presumptive exclusion of ocean energy development. And there's a way to overcome that exclusion. It's a pretty high bar. You have to show that there are no alternative sites for that development, and you have to show that there's no reasonably foreseeable effects on the ISUs for that development. And the reason I divided the conservation areas into those two is because conservation areas, if you remember, were a result of a combination of the fishery and natural resource information. So there are some areas where it was purely the fisheries information that brought it into that management unit. So those areas don't have the ISUs. And then there's some that are based mostly on the natural resource information. Those do have the ISUs. So that's why there's a little bit of a difference there. And when you think of these areas, I kind of think of the ISU as kind of an overlay zone that indicates where this higher standard needs to be applied. Most of the ISUs are in resource use conservation areas, but there are also some that are located in the other management units, and those are primarily a result of that kind of last-minute addition of the river mouths. So if an ISU is located in a different management unit, it still gets that standard. So it still has a presumptive exclusion standard. So that's really regardless of what management unit it's located in.
I just wanted to fact check, how many more slides do you have?
0. But I will say that I don't have a slide of it, but the fishery standards have a similar kind of hierarchy like this, where they become more stringent as you move up into the higher standard, and the fisheries ones do have a presumptive exclusion standard as well on them. That's it.
Excellent, thank you. And I did, David, since you said you weren't going to take as much time, I gave him 5 minutes here, so that's okay.
Thank you.
That is a problem we'll fix. So thank you, and we'll ask some clarifying questions in a few minutes. Sure, from David first.
So as I told Andy, is it on?
You guys got really close.
Okay, so as I told Andy, I came today pretty much to answer questions. I didn't really have anything to present, so I sent 2 attachments, and I think Andy forwarded them. The first attachment was the timeline that was prepared, I think it was prepared by Paul Claren as part of his staff report back in 2013, which really laid out all the public meetings and all the different interactions, and that's one of the attachments, hopefully the OPAC members today got a copy of it. So you can look through that. That provides a summary of the timeline, starting with the MOU with FERC, the governor's executive order in 2008, moving into the territorial sea plan working group, the OPAC meetings, moving back to TestPac, back to OPAC, a 5-year process. So rather than going through it, folks can just look at it, and if they've got questions, they can ask me, and then I can perhaps provide some clarification. So that's the first thing that I'd like to mention. The other one, attachment, had to do with moving forward. I know we're talking about what happened, but I'd like to focus at some point on the staff recommendation and moving forward. And even though I know OPAC is not making the initial determination, that will be next week at the commission meeting, I provided some comments back and forth with Andy. Andy, I'd like to thank Andy for having some phone conversations with me to kind of go through it, and I want to make sure Steve Shipsey had this as well, so he was aware of my position on the staff recommendation. And without going into detail, I have differences of opinion as far as the recommendation, as far as whether it complies with the statute, and I guess we're just going back to my differences of opinion back in 2013. The court resolved that, so I guess we'll just have to see how things progress to see if there's going to be any further differences of opinion and how that may play itself out in the future. But I do want to say, and I told Andy this, I do think the changes as far as moving the Puma into the exclusion area and removing some of the controversial REFSA sites is a step in the right direction from a substantive standpoint. But again, the procedure as far as compliance with the statute, you can look at my comments. I think the OPAC members have it. They can look at what I said about the staff recommendation. And if there's any questions, I'll just wait until we get through everything, and I can then perhaps provide clarification. And I'd also like to hear what Jason Bush has to say about the industry perspective. And I may have to address some of his comments to see if I may agree or disagree with what his perspective is based on the history of this process and also in moving forward. So again, I'm here to provide clarification, answer questions, and that's pretty much all I have to say at this point.
Okay, well, thank you, David, for driving over to do this. And two things, I just want to make sure that people do have in their inbox, which you should have from Andy, the 2 documents that David Allen is referencing. I think they were sent yesterday.
Yes, and I can pull those up on the screen if we would like.
Okay, and then also, I have 2 people with their flags up. And I also want to make sure if anyone has any clarifying questions for either one of them at this point, we have an opportunity, like if you have a specific ecological question, the slide can start. So Andy, you were first.
I just wanted to say that I can pull those up at the council's request.
John?
Okay, David, this is not an opinion, it's just a question. And I'm looking at the judgment document. It's the litigation results.
Court of
Oh, okay.
Appeals.
Okay, I think I have that in my book. Yeah, I know what you're talking about. It's the appellate judgment.
Yes.
Yeah.
Whatever it's called.
Yeah.
Okay, I'm looking at this, and I'm listening to what's going on. And there's a third avenue that I see that hasn't been addressed. And on, well, it's page 8 of the PDF, and the number in the box is 662. And it's the territorial sea plan review requirements.
I'm not sure, I have no idea what document you're looking at right now.
Do you all want to, do you want to come look at his computer? He's supposed to be looking at his computer.
Let me just see.
I'm looking at the attachment we got, that is the court judgment, the result or whatever.
Are you talking about the opinion?
I don't know what it's called.
No, that's heck.
Just scroll back.
Let's go to the top.
Yeah, that's the actual court decision.
That's
Court
it.
decision,
Okay. Yeah.
and you call it an opinion?
It's a, yeah.
Okay.
Okay, I know, yeah, I got that.
Now, where was it?
Page 662. Page 8 of your
Yeah, I've got it. So what John's referring to is the actual court decision that came down after our legal challenge. It's the one that's been published in the Court of Appeals publications, and I think everyone's got a copy of it, or they should have gotten it actually at the last OPAC meeting as well. So.
Okay, can I move on?
Yeah, you can ask your, I just wanna make sure we're all looking at the same document when you ask your question.
I wanna state what I see here and then comment about what I see and my interpretation of it. It refers to the territorial sea plan review requirements, provides, and there's two items there. Excuse me, there's number 1 and then A and B. And A is carry out the policies of ORS 196405 to 196515. And B are consistent with applicable statewide planning goals with emphasis on the 4 coastal goals. Now it looks to me like the commission in 2013 found that it satisfied these A and B requirements. Is that correct?
So I'm going to go and just base it on what the commission and the DOJ briefs said. So again, Steve, if you want to jump in on this, since you're a DOJ attorney, and I don't want to speak with DOJ on this, but I'm just going to go with what the agency's brief was that was submitted to the Court of Appeals as part of this legal challenge. And the brief said, and I actually provided this in my comments, which are the attachment that Andy provided to the group. And without going into detail, it was indicated in a number of places, not only in the documentation, but in the briefs that were submitted by the agencies, that the commission had made findings that the OPAC recommendation as originally submitted to the commission did comply with the applicable statutes and statewide planning goals. I'm just basing that on what the brief said that the agency submitted, not on anything that I've reached as a conclusion. So I'm using their own language to answer your question. That's really all I have to say. I mean, unless Steve wants to jump in and add to that, there's not really much more to say other than that's what
Happy to. The commission's order was based on the OPAC recommendation as modified by TESPAC and the Department of Conservation Development staff report recommendation. So the findings were based on the modified submittal that LCDC was approving.
Well,
So there were no findings on the OPAC recommendation?
so John, I'm just going to read from the agency's brief right now. The agency, and I'm stating what they said in their brief, quote, "The commission made exhaustive findings that OPAC's recommended amendments complied with the applicable statutes and statewide goals." You can determine how you want to read that, but I'm just reading the language out of the agency's brief submitted on behalf of the LCD in the legal challenge.
Well, and so for folks that aren't tracking this conversation as closely, and if people haven't done all their homework on it, let me ask a question. David, can you just explain the importance of why having findings? Like, I understand that that's the critical issue, and I understand that whether findings are made or not open up avenues to approve to OPAC 2013 recommendations. If findings haven't been made, then it seems like that is a hiccup. And if they have been made, then other paths are, it helps clear the path, my understanding is, to the 2013 OPAC recommendation adoption. Is that correct?
Yes.
It's kind of like a road, it's like a traffic.
It's a roadmap
Yeah.
that the statute provides.
That's not where I'm going.
But anyways, that's the answer to your question.
Oh, I took a wrong turn, as
Well,
you just said.
I'm just here to answer questions.
Oh.
Okay, I haven't gotten back on the freeway here. If they made that determination that it did meet procedural requirements, then now I see a conflict. The staff is saying that they do not approve what is at option 3, which is the 2013 OPAC recommendations, because it's not up to date. So procedurally, I would think another option would and say it does no longer meets A and B, and because of, according to staff, because of passage of time and the things that have changed, that they could then say, do a do-over with that's up to date from OPAC and submit us something that does meet A and B by today's knowledge or whatever you call it. Is that possible?
Well, I think I pretty much said that in the comments that I submitted that Andy forwarded on to the OPEC members. I think I laid that out as a possibility, so, yes.
So that's a pathway that's not listed in any of our, except for what you said.
So, sorry, it's hard to bring up all of our.
So, like I said, in my view, everything starts with the OPAC recommendation in the statute. If you look at the different subsections, the first subsection 1 says, and this was what I argued, and for the most part, the court agreed with me in my position, that it starts with the OPAC recommendation. If the commission makes findings that the OPAC recommendation complies with the applicable statutes and statewide goals, in my view, it must adopt the OPAC recommendation. If it can't make those findings, then it needs to determine what revisions need to be made and then send it back down to OPAC to revise. But if OPAC's recommendation met all the statutory and planning goal requirements, my reading of the statute is that's what's to be adopted. At this point in time, in my view, based on the documentation that the agency submitted during the legal challenge, and I'm just using their own language out of the order that Jim Rue provided as well as the agency's brief, the required findings were made with respect to the OPAC recommendation before any modifications were made to that OPAC recommendation. Now, there may be a difference of opinion, but that's my reading of what occurred. If that's the case, if the commission wants to send the OPAC recommendation back down to OPAC at this point in time, it's my belief that the commission needs to revisit the OPAC recommendation and determine whether new findings need to be made that may suggest OPAC, under the new circumstances, no longer can meet Goal 19 and or the applicable statutory requirements because of changed circumstances over the past 5 years. In doing that, they can still make needed revisions and send it back down to OPAC and we'll get to the same point. But more importantly, they'll be working off the OPAC recommendation as a starting point rather than, in my view, bypassing it. And that really gets to the procedure that I've always been focusing on. Start with the OPAC recommendation and work from there. Don't bypass it, don't modify it, work through the procedural steps in the statute. And I have a difference of opinion with the DOJ attorneys. We got it resolved by the court last time, and we have an ongoing difference of opinion at this point in time, and that's okay. Attorneys, I'd like to disagree.
And I think that was an excellent summary of what the discussion point is. And so I think that's very helpful. And,
And that's all, yeah, that's pretty
so I
much
think
it.
that was very helpful. Thank you. And I don't think there's any role, the situation we're in right now is there's no role for OPAC in doing anything about that at this moment because the commission is meeting next
Yeah.
week and they will figure out, they should have
Right.
this information and figure out their path forward.
And I just want to say, I've served on OPAC for 13 years before last year, and even though I'm saying Steve and I may have a difference of opinion, we've always worked well together, and I think even though we do have differences of opinion, like I do with many attorneys and vice versa, I think it's just a professional difference, and it's just really about how we interpret things. So at this point, I think there's not really much more I can say about, what needs to be done. I think that's going to be up to the commission next week. What I provided to OPAC as an attachment will be my submitted written testimony to the commission next week. So hopefully Steve, in hearing me today, will at least understand my position. Since I will not be there next week, I have to be at the League of Oregon Cities annual conference in Eugene all next week, so I won't be able to attend the commission meeting next week, unfortunately.
We'll connect beforehand.
Okay. And that's all I have to say on the staff report and moving forward. I'd like to answer questions if necessary on the 5-year process that led up to 2013, if people have questions about that as well.
Yeah, and one thing we're gonna do too is after we have heard from the last two speakers, we'll bring everybody and have additional discussion. So at this point, unless you're adding any clarity to, it really needs to be a clarification question, and I'm gonna move on.
I have a clarification question.
Do you have, should we?
Well, I tried to respond to John, his question.
Okay. Sure, go ahead.
So what I understood John to say, and I must say I'm not tracking this conversation 100%.
Either amount.
Whatever slide number this is on page 11 from Andy's presentation this morning gives us 4 alternatives.
Let me go through those.
And what I understood John's question to be was that the pathway for revision of the OPAC recommendation is not on here. But I see that it is on here.
Oh, it is.
And then, and so, right, so I think that the answer is that it is an alternative and it is in motion, and that's the question mark.
Is
that correct?
I will say this, I think the alternative 2 speaks to it the most, but it doesn't clearly specify what I just said. It's basically saying the commission could adopt the OPAC recommendation, but then it says, well, it can't do that for various reasons. What I'm saying is, the commission, in my view, needs to take a look again at the OPAC recommendation right now under today's circumstances versus what happened in 2013 and ask itself. We made findings, and I believe the commission made findings in Jim Rue's order as well as based on the agency's brief. They made findings that OPAC's recommendation in 2013 before any agency modification. So we're sticking just with the OPAC recommendation now. Findings were made as indicated in the briefs and in every other document that OPAC met its requirements, but the agency still wanted to modify it, and that's what got us hung up, and that's what led to the legal challenge. What I'm saying is, those findings are now in place. If the commission wants to send something back down to OPAC, again, it needs to revisit those findings it made in 2013 and ask itself, under today's circumstances, maybe OPAC no longer meets those requirements or those rules, so let's tell OPAC, this is what we want you to do to revise things so we can now, again, make those findings that we made in 2013 under the present circumstances. It gets you to the same place, meaning I like a lot of the things that Andy and the staff report suggests. So it's not about the ultimate result, it's about the procedure you use to get to that result. And in my view, that procedure is important, and it's not just any minor procedure, as I see in a lot of the documents that have been unfortunately distributed by the agency. This was just a minor procedural misstep. No. A minor procedural misstep would be maybe a notice not having all the required information for rulemaking. I mean, those are the kind of procedural steps that are sometimes missed. This is a procedural step under the statute that really gets to the heart of authority and who makes decisions initially and who makes them ultimately. And that is not just a procedural step, it really gets to the issue of authority and who's got responsibilities to do certain things at certain times. So that's why I'm really focusing on this procedure. And it's not just a minor procedure because it was hard fought. Hundreds of hours were put in by both sides in the legal challenge. So if this was just a minor issue, why would the agency put in hundreds of hours of attorney time to challenge it? So again, it was a procedure, but a very important procedure that I think OPAC today needs to understand gets to the role of OPAC with respect to the commission in amending the territorial seat plan, not only for Part 5, but Charlie, as I've told you, for Part 3 and any future amendments that might come across your OPAC. So I'm trying to set a precedent to help OPAC, not for just Part 5, but for the future, when all of you are no longer on OPAC, and there's going to be new OPAC members that may not remember this, but at least the court opinion will be there that they can rely on.
Thank you, Dave. Patty, anything else to add, and then we're gonna move on to the next one.
Just reaffirming what Karen was saying, that was what I was gonna point out, is that those 4 recommendations are laid out here in the staff report to the commission, so it didn't include, I believe it addresses the option that you were looking at. I just wanted to clarify that.
Thank you, we'll bring you all back for additional discussion. So then our next panel. Sorry, I'm copying the mic. We'll be having Jason Bush providing industry perspective on Part 5, which is kind of the past Because you have to get really close to the mic for your voice to be picked up. It's a pretty, it's uncomfortably close, so.
Understood. Well, thank you very much for the opportunity to talk with you today. My name is Jason Bush. It's been a while since I've seen many of the faces in the room, and there's some recognized, certainly a lot of folks, and there's some new faces as well. I'm here to just provide a few perspectives from the marine renewable sector, which includes today wave energy in this area, as well as floating offshore wind. Tidal is not technology that a resource that we have in Oregon, so it's not really on the table. It's a wave and floating offshore wind. Like David, I don't have much in the way of prepared comments. I'd like to field questions, so feel free to put your hand up any time. If you want to just get to something, let's just go there. In part because I did hope we would have a conversation and not me just yapping at you. But also because this has been a long week. This is our annual conference. It was this week. I've been working all summer to make that happen. It's over. And as soon as this is over, I'm going to go home and go sleep. So big conference, best attendance we've ever had. But I'm glad it's over. So I think it's important to recognize that we live in a little bit different world today than we did 10 years ago when I first started with this process, with a project, OPT, breathing down our necks, a company that seemed to be moving quickly toward actually doing a project. They were building machines, they got their FERC license, they went through the whole process, and it seemed like it was going to happen. And I think it caught a lot of folks by surprise. At the time, at least from my perspective, and from the state's perspective, at least from the perspective of that group, the Business Oregon that supported the Oregon Wave Energy Trust, we thought this was moving very, very quickly, and there were many reasons for us to address that challenge, that opportunity, that threat, and make sure that we were thoughtful about it. The TSP was part of that process. So it's been a lot of other work that we've done over the years regarding better understanding of the potential environmental effects of marine renewable energy, how it affects stakeholders, what the real opportunities are, the viability of the technology, the appropriateness of the technology, a whole host of questions that are complex, and we're still grappling with them. I think OPT is an interesting case study, and it reveals a lot about the sector. So OPT is no longer around in this original form. It's still out there, and it reflects the fact that a lot of companies in the marine hydrokinetic sector are recognizing that there is more than one way to bring their technologies to market. It's not just about utility scale projects anymore, right? Utility scale energy projects, big projects, multi-$100 million projects. There's also what we're now referring to as maritime markets. And I bring this up because I think Dan will probably touch on this just a little bit because it's kind of a big deal in our sector. There's a report that came out recently, Department of Energy, finally recognizing that a machine that can create electricity from the motion of the ocean could be useful for something other than just utility scale projects. I can't remember all of them. I think there's 14 they came up with. Aquaculture, ocean observation, buoys. That's a good example. You got a buoy out in the water. Somebody's got to go out on a boat with batteries every once in a while, replace the batteries. What if the buoy itself was a wave energy machine and it charged its own battery? So you can see why somebody might have a good idea. Keep going. Desalinization, seawater mining to extract all kinds of things from seawater: gold, uranium, hydrogen. There's several others. And so that aspect of the industry is beginning to grow. And several companies, including Ocean Power Technologies, doing that now. They've actually made progress on that front. So they're still using that same basic machine design, but instead of making electricity for the grid, they're doing it for the military, for ocean observation, for NOAA, and around the world, for a whole variety of uses. Some of those markets are into markets in and of themselves. The companies will make money doing that. Others will do those things in part because it helps them develop technology, allows them to get their machines in the water and actually produce electricity over a period of time, learn, renew, revise, update, improve, and reduce the cost, increase reliability, and scale it up to where it really is viable as a utility scale machine. It's a form of generation that can compete on cost and on a variety of other factors with a growing array of renewable energy resources that are out there. So there are a number of these I'm not going to spend too much time on the alternative markets, but not because they're not really important. They are. In fact, I think they're going to significantly outpace utility scale wave energy, at least for the foreseeable future. Let's focus on utility scale technologies. What's happening? OPT is the only company in the world that kind of didn't make it across the finish line. There's several of them. Some of them are bankrupt, others have sort of disbanded or gotten absorbed by other companies. Collective knowledge, the overall function of the technology and of the companies that are still tracking continues to improve, as you would expect from any technology development. I see a note here. I wanted to go back and very quickly address Andy's comment about Andy, sorry, I just wrote to address Andy's comment.
Maturity of the industry or technology development curves?
Yeah, technology, convergence, exactly, thank you. So the question is what we refer to as convergence of technology. So, for example, if you were going to build a combined cycle natural gas plant to make electricity, there's one design, it's the same basic machine, there's just a handful of manufacturers, but it's the same basic design. Same way with the wind turbine, it's more or less a three-bladed upwind device. Everybody's building the same thing. They're just adding different bells and whistles and making them more efficient, more reliable, and bigger. Wave energy, that has definitely not happened yet, but the basic move of convergence is still very much there. We are converging. It's just that for a couple of main reasons, we have not yet converged. One, there's more than one type of market out there. We talked about the maritime markets, but put that aside. But for utility scale markets, there's different places to do utility scale projects. In some cases, the wave regime may be very significant, like off the coast of Oregon. Or you might have issues, you might think about, say, Alaska, where you have remote villages that are currently importing diesel and spending a lot of money on their electricity. There are low wave regime environments like equatorial areas. And so different machines will be needed in order to meet those different market needs. So while we have not converged on the three-bladed upwind design that would be the equivalent of an offshore wind turbine or a modern wind turbine, we are moving in that direction, and we are still many years from this happening. I think what's interesting to see in the industry right now is the maturation of the companies. The less talk, they're quieter as an industry. They're still busy working and not talking so much about trying to get to commercial scale today. What you saw with OPT is unprecedented in any other company, which was they had a bunch of money. They had two initial public offerings, one in the United States, one in the UK, $150 million originally. And they spent it to try to bring their technology to market first so they could make the shareholders happy. It didn't succeed on that. Today, companies aren't talking about rushing to market. They start talking about things like going through the iterative process. There's no substitute for putting a project in the water. You can do tank tests all day long, but there's no substitute for putting big machines in the water and watching them function and assessing them over time. You learn something there you can't learn any other way, and that's what's happening around the world. There are machines in the water all over the world. There's only one commercial project. It's barely a commercial project. It's actually a land-based device. Does that mean
5 minutes.
5 minutes? Oh, no. Thought I had nothing to say.
That would be a first.
That would be a first one. Anyway, it's connected, it's a big concrete structure that protects the port. And has wave energy generation. So these companies are all tracking it, and what we have in the United States on the West Coast, I think, what's gonna happen in the next few years, my crystal ball is, there have been a number of companies that have deployed at the wave energy test site located in Kailua, Hawaii, at the Navy test site, the wave energy test site. It's grid connected, they got a 30, 60, and 80 meter site there. It's kind of a bathtub, it's not open water. So only when storms come through do the machines really get kind of put through their paces. It's just a good place to get your machine wet for the first time. It's warm, it's free. It's gentle. So there have been four deployments over the last 3-4 years. These are full-scale machines or near full-scale. There's I lost track, at least that many or more that are in line to deploy at one or more of these sites. There's significant DOE money flowing to these companies along with Navy money, along with an increasing amount of private sector money. The numbers are going up. It costs a lot to build a full-scale machine and stick it in the water for a couple of years. So that's a slow, arduous, expensive process, but it is churning away. When those companies come out of wets, they want to go into a more vigorous environment, and that is PNEC, Pacific Marine Energy Center, PACWay, the test site that's being built off of Newport, and Dan will tell you more about that. They've all expressed interest in sort of graduating from the wet site at Hawaii and going to a place that's really going to push their machines, put it through its paces, and prove up the technology. So I think PACWay represents, from my perspective, I think from the industry's perspective, the obvious choice for the next round of deployments. It's a pre-permitted site. It's a structured, well-developed site run by the university and academic researchers. There's a lot of support around it, and it makes all the sense in the world to do something there rather than try to do something anywhere else on their own. It just doesn't make sense. The exception to that is Camp Rilea, which is a fairly unique area, really, in the world for wave energy machines, because it is a gradual slope with a controlled area around the test site. There are a number of companies that are interested in going there, and we may be seeing some news about that in the next few weeks. So that site is still very much of interest, different than PACWay, because PACWay is a deep site, and it can accommodate a certain range of technologies, while Camp Rilea can accommodate a different type of technology that sits more than near shore and is bottom mounted. Some general comments about the Territorial Sea Plan. TSP, I didn't start that process. I came in 2009. It took me quite some time to kind of get up to speed on that, and I think it was a real eye-opener for me as a learning experience, as the first public process that I had been through. Many lessons learned, a few scars. I think that TSP was a product of a great deal of effort. For those of you involved, you're well aware of this. I think that with a lawyer's eye, I'm not a practicing lawyer anymore by a long stretch, but I feel like it was a very well hashed out document. We went over the language almost ad nauseum to try to make sure that it was clean, that it was redundant, that it addressed our basic needs to protect the ocean, to meet our obligation under Goal 19, while accommodating an emerging sector, clean energy from the ocean. And I think we more or less struck that balance. I've seen the comments or the proposal from Andy. I won't quibble with any of that. I think it's a necessary path forward. What we all know is that right now the situation is we're stuck with a 2010 version, which certainly is not adequate in any number of fronts. It certainly doesn't protect the state. It's not nearly as protective of Goal 19 resources, and we need to get something in its place. I'm not gonna, as an industry rep, insofar as I am an industry rep, again, the mission of POA is to promote the responsible development of marine energy. Time to stop. Sorry about that. I think it's important we move forward with a plan that looks essentially like what we have. I think if we end with that, it will provide sort of a steady state and keep moving in the right direction. I'll stop there, and I'm happy to answer any questions.
Thank you very much. Dan?
Thanks for the opportunity to talk with you again. I presented to OPAC earlier this year. That was largely focused on our what was called PMEC sets. It's now PACWave South. Just to give a little bit of background, because the naming has all changed significantly. I'm not going to get into a lot of detail about that. But formerly we were NEMREC, the Northwest National Marine Renewable Energy Center, which is a coalition between OSU, University of Washington, and University of Alaska Fairbanks. NEMREC still exists. It's now goes by the name of PMEC for the sort of umbrella organization. At OSU, we were housed in the College of Engineering with Belinda Batten as the director. When we were awarded the funding from the Department of Energy to actually move forward with our South Energy Test Site, it was decided to NEMREC had, sort of had a number of different roles. There was a lot of research that was going on. There was also the open water testing piece, wave energy device testing, and it was decided at that point, with sort of moving ahead with the big project, was to separate out the research side of things and manage the testing separately. And the testing part of it moved to the College of Earth, Ocean, and Atmospheric Sciences, and got renamed PACWave after lots of discussion. The reason we moved to CEOS was that CEOS has a lot of experience with oceanography and with deployments of equipment out in the ocean, which is obviously more applicable to a test site. Under CEOS, you have ship operations at the university. They're also very involved, have been involved, and continue to be involved in the Ocean Observatories Initiative, putting a lot of gear out in the water, cables, instrumentation, and they're also involved in the design and construction of two new regional class research vessels to basically replace some of the sort of aging fleet in the US for oceanographic work. So it was a good place for us to fit, and so PACWave moved there. So our focus is on wave energy testing, open water testing. We have one site in existence, the North site, which was previously sometimes called the Open Ocean Test Berth or the Ocean Open Test Site, was also called the North Energy Test Site, and is now basically PACWave North. And hopefully we will stick with that name and stop changing things. And then we have the South site, which is our large grid-connected site that we got DOE funding for, and which is in the design and permitting and planning stage, with the hope of moving into the procurement and construction phase in 2019, and hopefully be operational in late 2021 or early 2022. I'm not going to focus on the South Energy Test Site on PACWave South to a great degree, because that's on the outer continental shelf, so it's outside of the territorial sea. Having said that, the cables from the site are going to run through the territorial sea, so obviously fall under Part 4 of the territorial sea plan. And currently we have a geophysical and geotechnical survey underway of Newport gathering data to satisfy the Bureau of Ocean Energy Management, but more importantly for us to finalize the cable route from the test site back to shore. So that's all underway. But really what I want to focus on for the rest of the time I have to talk is our North site. As Andy mentioned, it's a smaller site. It's 1 square nautical mile off Yaquina Head. It's not grid connected. Currently there is nothing out there. It exists on paper, but there's no equipment there. We had a device tested, the Wet NZ device, in 2012. The hope was that people would be clamoring to test there every year between then and now. That 2012 test was the only test that's been done. A lot of funding kind of dried up in the industry. DOE weren't funding tests. We did another deployment of one of our pieces of equipment to do some mooring load testing, but otherwise there's been no device testing at that site. Our focus has very much been on trying to get our south site up and running. The north site, as Andy mentioned, is a renewable energy permit area. So compared to other areas, it's relatively easy to come in and test there if people want to do it. We have a number of people who have expressed an interest